Before we begin, a quick and important disclaimer. This video discusses financial assets, divorce law, and retirement accounts within the context of American social studies and historical legal trends. This content is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce laws vary significantly by state, and individual circumstances differ. You should consult with a qualified attorney or financial professional before making any decisions regarding your personal situation. Conduct your own due diligence. Imagine working for 35 years, diligently contributing to your 401k, watching the compound interest turn a modest monthly sacrifice into a mid-six-figure or even seven-figure nest egg. You've sacrificed vacations, driven older cars, and maximized your employer match, all under the assumption that this mountain of capital is your personal safety net for the golden years. Now imagine walking into a courtroom and realizing that, in the eyes of the law, that money might not be yours alone. In fact, for many Americans, the 401k is the single largest asset they own, often surpassing the equity in their primary residence, and it is also the asset most likely to be misunderstood, mismanaged, and ultimately dismantled during a divorce. We are currently witnessing a phenomenon social scientists call the silver divorce. While overall divorce rates in the United States have seen historical trends of stabilization or even decline among younger generations, the divorce rate for those over the age of 50 has roughly doubled since the 1990s. For those over 65, the rate has tripled. This shift has massive implications for the American economy because it moves the discussion of retirement from a solo journey to a complex legal battle over communal property. In this deep dive masterclass, we are going to break down the social and legal architecture of the 401k divorce. We are going to explore the specific federal laws that govern these accounts, the step-by-step process of the Qualified Domestic Relations Order, or QDRO, and the potential outcomes of asset division that can leave one or both parties with significantly less than they projected for their retirement. If you have ever thought that your retirement account was protected simply because your name is the only one on the statement, what we uncover today will change your perspective on American financial law forever. The problem we are solving today is the information gap. Most people enter a divorce focusing on the house, the cars, and the custody of children, treating the 401k as an afterthought or a simple split. But the 401k is a tax-advantaged vehicle governed by a complex web of federal and state statutes. A mistake in how this account is divided doesn't just cost you half the balance. It can trigger immediate 10% early withdrawal penalties, massive income tax liabilities, and the loss of decades of future growth. By the end of this 10-part series, you will understand the historical trends that led to our current system, the difference between community property and equitable distribution, and the exact mechanics used by the court to value and carve up a lifetime of savings. To understand where we are, we have to look at the social studies aspect of the American retirement shift. Historically, Americans relied on defined benefit plans, traditional pensions. In those scenarios, the company promised a monthly check for life. Divorce was simpler because there wasn't a pot of money to split right now. There was just a future stream of income. However, starting in the late 1970s and accelerating through the 1980s, the U.S. shifted toward defined contribution plans, primarily the 401k. This shifted the risk from the employer to the employee, and it turned retirement into a tangible, liquid asset. The foundational piece of legislation you need to know is ERISA, the Employee Retirement Income Security Act of 1974. ERISA is a federal law that sets minimum standards for most voluntarily established retirement and health plans in private industry to provide protection for individuals in these plans. But there was a problem. ERISA originally had an anti-alienation provision. This meant that, by law, the money in a 401k could not be assigned or transferred to anyone else. This created a social crisis during divorces. If a husband had the 401k and the wife was a stay-at-home mother, the court often found it impossible to give the wife her fair share of that retirement because federal law blocked the transfer. This led to the Retirement Equity Act of 1984, or REA. This was a landmark moment in American social history because it recognized that marriage is an economic partnership. The REA created the Qualified Domestic Relations Order, which provided the legal key to unlock the anti-alienation gate. It allowed a state court to tell a federal retirement plan, "You must pay a portion of this account to the ex-spouse." This transformed the 401k from a personal account into a marital asset. When we talk about the 401k in a divorce context, we have to address the two primary legal philosophies used across the United States: community property and equitable distribution. This is where your geographic location becomes the most significant factor in your potential outcomes. In community property states such as California, Texas, and Arizona, the law generally views all assets acquired during the marriage as owned 50/50 by both spouses, regardless of who earned the money or whose name is on the account. If you started a 401k the day after you got married and put in $1 million over 20 years, your spouse is typically entitled to $500,000 of that balance. It is a rigid mathematical split. However, the majority of U.S. states follow the principle of equitable distribution. Here, equitable does not necessarily mean equal. The court looks at a variety of factors to determine what is fair. This might include the length of the marriage, the age and health of each spouse, the earning capacity of each person, and the contribution of a non-working spouse to the education or career of the working spouse. In an equitable distribution state, a judge might decide that a 60/40 split is more fair, based on the specific case study of that couple's life. Let's look at a step-by-step case study to illustrate the complexity of valuation, which is often the most contentious part of the process. Consider a hypothetical individual, Michael. Michael started working for a tech firm in 2010 and began his 401k. He married Sarah in 2015. At the time of the marriage, Michael's 401k balance was $100,000. In 2025, they decide to divorce, and the balance is now $500,000. A common mistake is assuming Sarah is entitled to half of $500,000. But the law typically distinguishes between separate property and marital property. The $100,000 Michael had before the marriage is his separate property. Only the $400,000 gained during the marriage is considered marital property subject to division. However, it's not even that simple. What about the market growth on that original $100,000? If that original $100,000 grew to $180,000 purely through market performance without any new contributions, is that growth separate or marital? Different states have different historical trends on this. Some states use a tracing method to separate every penny, while others might look at the active versus passive appreciation. This brings us to the actual mechanism of the split, the QDRO. You cannot simply go to your HR department and say, "Give my ex-wife half my money." If you did that, the IRS would view it as a distribution to you. You would owe immediate income tax on the full amount, and if you are under 59.5, you would hit a 10% early withdrawal penalty. The QDRO is a specific legal document, separate from your divorce decree, that is drafted by attorneys and approved by both the court and the 401k plan administrator. It instructs the plan to create a segregated account for the alternate payee, the ex-spouse. This allows the money to move from your 401k to their IRA or their own 401k without triggering taxes or penalties at the moment of transfer. Throughout this masterclass, we will dive deeper into the alternate payee options. Did you know that a QDRO is one of the very few ways a person under 59.5 can actually access 401k cash without a 10% penalty? If the court orders a distribution via QDRO, the receiving spouse can often choose to take a cash lump sum. They will still owe income tax, but the 10% penalty is waived under Internal Revenue Code Section 72(2)(c). This is a critical historical trend in divorce settlements where one spouse needs immediate liquidity to buy a new home or pay off marital debts. As we move forward, we will analyze the double dip phenomenon, where a 401k is divided as an asset, but then the income it produces is later challenged as a source for alimony. We will also look at the massive data sets regarding the gender wealth gap in retirement, and how the U.S. court system has evolved to address the reality that many women, specifically those who took time out of the workforce for childcare, enter their senior years with significantly lower 401k balances than their male counterparts. This isn't just about a bank account. It's about the sociology of the American family and the legal framework that attempts to balance the scales of a lifetime of shared labor. To understand the forensic breakdown of a retirement account, we must first master the concept of the coverture fraction. This is the mathematical heartbeat of almost every 401k division in the United States today. As we move through 2026, courts are increasingly relying on this formula to untangle decades of contributions and market growth. Imagine a professional named Robert who works in the aerospace industry. Robert started his 401k back in 2006. He married his spouse, Sarah, in 2011. Now, in 2026, they are finalizing their divorce. The court has to decide how much of Robert's $1.5 million balance belongs to the marriage, and how much belongs solely to Robert. The coverture fraction operates on a simple but rigid logic. The numerator represents the total number of months the employee participated in the plan while married. In Robert's case, that is the duration from the wedding in 2011 to the date of legal separation or divorce filing in 2026. The denominator is the total number of months Robert has been in the plan since he started in 2006. By dividing the months of marriage by the total months of participation, the court arrives at a percentage. This percentage defines the marital portion of the 401k. Only this specific slice is subject to equitable distribution or community property laws. If the calculation shows the marital portion is 60%, then the court only has jurisdiction to split that 60%. The remaining 40% is Robert's separate property, theoretically untouchable by the divorce decree. However, the reality of 2026 financial markets introduces a chaotic variable: passive appreciation versus active contribution. In a deep dive social studies analysis, we see that modern courts are struggling with how to treat the growth of the money that was already in the account before the marriage. If Robert had $200,000 in his account on the day he said his vows, and that $200,000 grew to $450,000 purely through market interest without Robert adding a single new penny, is that $250,000 of growth marital property? Historical trends show a massive split in how different states answer this. In some jurisdictions, any growth on a separate asset remains separate. In others, if the growth happened during the years of the marriage, it is viewed as a marital gain. This is why we see high-stakes legal battles involving forensic accountants who must go back through 20 years of statements to trace the origin of every dollar. This process is called tracing. It is a step-by-step reconstruction of the account's history. The accountant must identify every contribution, every employer match, every loan, and every market fluctuation. Let's look at a potential outcome involving a 401k loan, which is a common scenario for American families in 2026. Imagine if, in 2023, Robert and Sarah took a $50,000 loan from the 401k to renovate their kitchen. In the eyes of the law, this is not just a debt. It is a withdrawal of marital assets that must be repaid to the separate property holder. If the loan is not fully repaid by the time of the divorce, it creates a massive complication for the qualified domestic relations order. Does Sarah's half of the retirement account get reduced by the outstanding loan balance? Or is Robert responsible for the debt because the account is in his name? Usually, the court will treat the outstanding loan as a distribution of marital funds already received. If they split the account 50-50, Sarah might find her share reduced by $25,000 because the court views that kitchen renovation as her having already spent that portion of her future retirement. Step 2 in this masterclass is understanding the role of the plan administrator. This is the person or entity, often a third-party financial institution like Fidelity or Vanguard, that actually manages the 401k for the employer. Most people assume that once a judge signs a divorce decree, the work is done. That is a dangerous misconception. The judge's order is merely a piece of paper until the plan administrator accepts it. Every 401k plan has a document called a summary plan description. This document contains the specific rules for how that plan handles a QDRO. Some plans allow for an immediate lump sum payout to the ex-spouse. Others require the ex-spouse to wait until the employee actually retires, which could be 20 years in the future. Imagine if Sarah needs that money now to buy a new home in the 2026 real estate market, but Robert's specific employer plan doesn't allow for early distributions to alternate payees. Sarah would be stuck with a ghost asset, wealth she owns on paper but cannot touch for 2 decades. This is why a professional script for a divorce negotiation must include a pre-approval process where the draft of the QDRO is sent to the plan administrator before the judge even sees it. This ensures the plan will actually honor the transfer. We must also examine the historical trends of employer matching. In the current 2026 economic environment, many companies have shifted to tiered matching systems or discretionary profit-sharing contributions. If an employer makes a massive profit-sharing contribution to Robert's account after the date of separation but based on work he did during the marriage, is that money marital? The social studies of labor law suggest that because the bonus was earned through efforts made during the marital partnership, it should be divided. This leads to the concept of the deferred distribution. Consider a case study of a teacher named Maria and her husband, Mark, a software engineer. Mark's company has a 5-year vesting schedule for their 401k matching funds. At the time of their divorce in 2026, Mark has $100,000 in employer matches, but only $40,000 of it is vested. The other $60,000 will only become his if he stays at the company for another 3 years. How do you divide money that doesn't technically exist yet? A common strategy in American courts is the reserved jurisdiction method. The court essentially tells the parties to come back in 3 years once the money vests. Or they might use a formula to calculate a present value discount, essentially saying to Maria, "We will give you a larger share of the house now in exchange for you giving up your right to that unvested $60,000 in the future." This is a high-stakes gamble. If Mark gets laid off or quits next year, that $60,000 vanishes. If Maria traded house equity for a portion of that unvested match, she has essentially traded a real asset for a disappearing one. As we dive deeper into the valuation of these accounts, we have to talk about the hidden impact of 2026 inflation. A $500,000 401k balance today does not have the same purchasing power it had 5 years ago. This has led to a new trend in divorce negotiations: the inflation-adjusted offset. Attorneys are now arguing that because the spouse keeping the 401k is getting tax-deferred growth, while the spouse getting the cash or the house is dealing with immediate inflationary pressures, the 401k should be valued at a higher rate. This complexity is why the 401k is no longer just a retirement account. It is a centerpiece of marital litigation. The math, the timing, and the specific rules of the employer plan create a labyrinth that can trap the unwary. But what happens once the numbers are settled? What happens when the money actually starts to move from one account to another? This is where the most devastating mistakes in American divorce history occur. Many people think the hard part is over once the judge bangs the gavel, but they are about to walk directly into a tax trap that could cost them 40% of their net worth in a single tax year. If you think a QDRO is just a standard form, you are missing the most dangerous part of the process. How you phrase a single sentence in that document determines who pays the taxes, when they pay them, and whether the IRS views the transaction as a legal transfer or a taxable event. In the next part, we are going to look at the specific tax codes that govern the movement of these millions and the one mistake that can trigger an immediate audit. We will also explore the secret way an ex-spouse can use a 401k as an emergency cash fund without paying the standard penalties, a loophole that is rarely discussed in standard financial planning, but becomes a lifeline during a divorce. This specific loophole is found within the Internal Revenue Code Section 72(t)(2)(c). Under normal circumstances, the federal government is very protective of retirement funds. If you attempt to withdraw money from a 401k before you reach the age of 59.5, the IRS views this as a breach of the retirement contract. Consequently, they hit you with a 10% early withdrawal penalty on top of the standard income tax. However, the American legal system recognizes that divorce is a period of extreme financial transition. Because of this, a distribution made to an alternate payee pursuant to a qualified domestic relations order is explicitly exempt from that 10% penalty. Imagine a character named Jennifer. It is 2026, and Jennifer is finalizing a divorce from her husband, Marcus, who has a 401k valued at $600,000. Jennifer needs $50,000 immediately to secure a new apartment, pay moving costs, and settle legal fees. If Jennifer were to take $50,000 out of her own traditional IRA, she would likely lose $5,000 to the penalty and another $10,000 to $12,000 to federal and state taxes, leaving her with only $33,000. But by utilizing the QDRO exception, Jennifer can request that $50,000 of her assigned share be paid directly to her in cash, rather than rolled over into a new retirement account. By doing this, she avoids the $5,000 penalty entirely. She still owes income tax, but that 10% savings is a massive lifeline in a 2026 economy where every dollar of liquidity counts. However, there is a technical trap here that claims thousands of victims every year. This exception only applies to 401k and 403b plans. It does not apply to IRAs. Historical trends show that many spouses make the mistake of rolling the money from the 401k into a personal IRA first, thinking they will take the cash out later. The moment that money touches the IRA, it loses its QDRO identity. If Jennifer rolls her $300,000 share into an IRA and then tries to withdraw the $50,000, she is now subject to the full 10% penalty because the 72(t) exception for QDROs does not follow the money into an IRA. This is a one-time opportunity that must be executed at the exact moment the 401k is being divided. Step by step, the process for this liquidity strategy requires the QDRO to be drafted with very specific language. It must state that the plan administrator is to distribute a certain dollar amount or percentage to the alternate payee as a taxable distribution, while the remainder is handled as a direct rollover. If the document is not crystal clear, the plan administrator might default to a rollover, locking that money away until Jennifer turns 59.5 or forcing her to pay the penalty if she tries to get it back out. Now, we must transition to the heavy burden of tax liability. In the United States, 401k money is pre-tax money. It is a tax-deferred liability waiting to happen. A common point of contention in 2026 divorce negotiations is who actually pays those taxes. According to Section 402(1) of the Internal Revenue Code, the spouse or former spouse who receives the 401k distribution via a QDRO is responsible for the income taxes. This seems straightforward, but it creates a massive imbalance in perceived value versus actual value. Consider a case study involving a couple named David and Linda. In their settlement, they decide to split assets equally. David keeps the $500,000 401k, and Linda keeps the $500,000 family home which has no mortgage. On paper, this is a 50-50 split. But in reality, David has received a massive tax bill. When David eventually withdraws that $500,000 for his retirement, he might pay 25% to 30% in combined federal and state taxes, meaning he only really has $350,000 of purchasing power. Linda, meanwhile, has $500,000 of tax-free equity because of the primary residence capital gains exclusion. In the social studies of American divorce, we call this the tax affecting of assets. A professional negotiator in 2026 will argue that the 401k should be valued at a discount to account for this future tax liability, perhaps valuing David's $500,000 account at only $375,000 for the purposes of the split. This leads us into the high volatility danger zone. Valuation dates. Imagine if David and Linda filed for divorce in January 2026, when the stock market was at an all-time high. The 401k was worth $500,000. But the legal process is slow. By the time the judge signs the QDRO in August 2026, the market has entered a correction phase, and the account is now worth $420,000. If the QDRO was written to give Linda a specific dollar amount, say $250,000, David is now left with only $170,000. He has absorbed 100% of the market loss, while Linda remained protected by a fixed dollar award. The opposite is also true. If the market surged to $600,000 and Linda was awarded a fixed $250,000, David reaps 100% of the gains on money that technically belonged to Linda during those months of waiting. To prevent this, professional scriptwriters of legal orders use the gains and losses clause. This clause specifies that the alternate payee's share shall be adjusted for market appreciation or depreciation from the date of valuation until the date of actual distribution. This ensures that both parties share the risk and the reward of the 2026 market fluctuations. Without this clause, the 401k becomes a gambling instrument during the pendency of the divorce. Step by step, you must determine if your state uses the date of filing, the date of the final decree, or the date of separation as the valuation point. In states like New York, the commencement of the action is often the cutoff. In others, it is the actual day the marriage ends. If you are in a volatile market, the difference of 30 days can mean a swing of tens of thousands of dollars in your retirement nest egg. We must also look at the administrative fees. Many viewers overlook the fact that plan administrators often charge a fee to review and process a QDRO. In 2026, these fees typically range from $500 to $1,500. While that might seem small compared to the account balance, the QDRO must specify who pays that fee. If the document is silent, the plan might deduct it proportionally from both parties, or it might charge it entirely to the employee. This is another layer of the forensic breakdown that requires absolute precision. There is also the issue of the 401k beneficiary designation. This is a social studies case study in administrative law that has gone all the way to the Supreme Court. Even if your divorce decree says your ex-spouse has no right to your retirement, if you forget to change your beneficiary form with your employer and you pass away, federal ERISA law often dictates that the person on the form gets the money, regardless of what the state divorce court said. This is the phenomenon of the plan documents rule. The plan administrator is legally obligated to follow the plan's documents and beneficiary designations, not your divorce decree. This creates a terrifying scenario where an ex-spouse could receive a windfall against the intent of the court. As we analyze these layers of risk, from tax traps to market volatility to beneficiary errors, a new question emerges that is even more critical for the long-term survival of both parties. What happens if the person owning the 401k dies before the QDRO is finalized? What happens if they retire and start taking payments before the court order is processed? There is a specific legal safety net called a joinder and a preliminary injunction that can freeze an account, but most people don't know they exist until it is too late. If you think you are protected because you have a signed settlement agreement, you are in a very vulnerable position. There is a gap between the settlement and the QDRO execution that can last months, and in that gap, your entire retirement future can disappear. In the next part, we are going to look at the death of a spouse during divorce, the survivor benefit protections you must include in your QDRO, and the specific ways to lock down an account so your ex-spouse cannot drain the funds before the court can divide them. We will also reveal why a 401k loan you didn't even know about could be the ticking time bomb that destroys your settlement. The 401k loan is often the most overlooked landmine in the entire field of marital asset division. In the social landscape of 2026, where inflation has squeezed household budgets, many couples have turned to their retirement accounts as a source of low-interest debt. Imagine a character named Brian. Brian has a 401k worth $300,000. His spouse, Elena, assumes they are splitting that $300,000. What Elena doesn't realize is that Brian took a $50,000 loan against the account 6 months ago to consolidate credit card debt. On the monthly statement, the balance might still show as $300,000 because the loan is technically an investment held by the plan, but the actual cash value available for transfer is only $250,000. The legal complexity arises when the court has to decide how to characterize that $50,000 debt. If the loan was used for marital purposes, such as home repairs or family expenses, the court will likely treat it as a marital liability. This means Elena isn't getting half of $300,000. She is getting half of the net $250,000. However, if Brian loses his job during the divorce proceedings, that loan usually becomes due immediately. If he cannot repay it, the $50,000 is treated as a deemed distribution by the IRS. Now, not only is the account balance reduced, but Brian is hit with a massive tax bill and a potential 10% early withdrawal penalty. In the high-stakes negotiations of 2026, a forensic accountant must determine who is responsible for the taxes on a defaulted loan. If the QDRO is not drafted to account for outstanding loans, one spouse might inadvertently inherit a tax debt they never signed up for. This brings us to the critical step of freezing the assets, a process known in legal social studies as a joinder or a preliminary injunction. In many jurisdictions, the moment a divorce is filed, automatic temporary restraining orders, or ATROs, go into effect. These orders prohibit either spouse from hiding, transferring, or dissipating assets. But here is the problem. A 401k plan administrator is governed by federal ERISA law, not state court ATROs. The plan administrator has no idea you are getting divorced unless you tell them. Imagine a scenario where a participant, fearing a 50-50 split, decides to change their investment allocation to high-risk options or attempts to take a hardship withdrawal. To prevent this, your legal team must file a joinder. This is a step-by-step process where the retirement plan itself is made a party to the divorce lawsuit. Once the plan is joined, the administrator is legally bound to notice the court's jurisdiction. This effectively locks the account. It prevents the participant from taking new loans, changing beneficiaries, or withdrawing funds until the QDRO is finalized. Without a joinder, you are essentially relying on the honor system, which historical trends suggest is a risky strategy in contested divorces. The most terrifying variable in this process, however, is the possibility of death during the divorce. This is a legal gray area that has left thousands of American families in financial ruin. Consider the case study of James and Samantha. They have been married for 25 years. James has a $1 million 401k. They have reached a settlement, but the QDRO has not yet been signed by the judge. Suddenly, James suffers a fatal heart attack. In the eyes of the law, because the QDRO was not finalized, Samantha is no longer the spouse if the divorce decree was already entered, but she is not yet the alternate payee. If James had already removed Samantha as his beneficiary after the divorce decree, but before the QDRO was processed, the money could go to a sibling, a new partner, or even the state. This is why a masterclass in 401k division must emphasize the pre-retirement survivor annuity, or QPSA. A well-drafted QDRO must include a provision that names the ex-spouse as the surviving spouse for the purposes of the plan's survivor benefits. This ensures that if the participant dies before the account is actually divided, the alternate payee is still protected. In the social studies of 2026, we see a rise in litigation specifically over these gap periods. Lawyers are now using nunc pro tunc orders, a Latin term meaning now for then, to ask judges to backdate QDROs to the date of the divorce decree in an attempt to save the survivor benefits. But there is no guarantee this will work. It is an uphill battle against federal statutes. Beyond death, we must analyze the social implications of the post-retirement survivor annuity. What if the participant is already retired and receiving a monthly pension or 401k annuity? Once the participant retires and selects a payment option, that choice is often irrevocable. If the participant chose a single life annuity, meaning the payments stop when they die, the ex-spouse cannot change that through a QDRO. They are stuck with a stream of income that could vanish tomorrow. This is why, in the 2026 economic environment, it is vital to audit the plan's retirement options before the divorce is finalized. You may need to negotiate a life insurance policy as a substitute for the lost survivor benefits, using the 401k value as the benchmark for the policy amount. Step by step, the forensic audit of a 401k must also look for hidden subaccounts. Many 401ks in 2026 are not just stocks and bonds. They might contain company stock, stable value funds with specific exit restrictions, or even brokerage windows where the participant has invested in everything from crypto-linked ETFs to gold. Each of these assets has a different liquidity profile. If the QDRO orders a 50-50th split of the account, but the account contains illiquid assets that cannot be divided, the plan administrator may reject the order. This leads to a total collapse of the settlement. You must ensure the QDRO specifies which assets are to be liquidated, or if the split should be done pro rata across all investment holdings. We also have to address the social shift in how we view the non-employee spouse's contribution. Historical trends have moved from viewing the 401k as a gift to the spouse toward viewing it as a strictly earned asset. This has led to the rise of the separate property credit. If Brian, from our earlier example, can prove that his employer made a massive contribution to his 401k as a signing bonus before he married Elena, he is entitled to a credit for that amount plus all the growth that specific money generated over the years. This requires a forensic deep dive into statements that may be decades old. In 2026, many older 401k records are being digitized, but there are still gaps. If you cannot prove the separate property exists with documentary evidence, the court will default to assuming it is marital. The burden of proof is entirely on the person claiming the credit. The intersection of ERISA, the Internal Revenue Code, and state domestic relations law creates a perfect storm of complexity. We have covered the loans, the joinders, the death traps, and the survivor benefits. But there is one final piece of the 401k puzzle that is perhaps the most contentious of all: the use of the 401k as a tool for alimony. In some jurisdictions, the court may order a QDRO not to divide the asset, but to pay out monthly spousal support directly from the retirement plan. This is a game changer for people whose ex-spouses are retired or have no other source of liquid income. However, using a 401k for alimony opens up a brand new box of tax complications and potential outcomes that can leave the recipient with far less than they expected. How does the IRS view these payments? Does the 10% penalty exception still apply if the QDRO is for support rather than a property split? The answers to these questions will define your financial reality in 2026 and beyond. In the next part, we are going to break down the specific mechanics of the support QDRO, the danger of the double dip where an asset is counted twice, and the precise way to calculate the present value of a future retirement stream so you aren't left chasing pennies in your 70s. We will also explore the psychological warfare of the valuation date, where choosing the wrong day of the week can cost you a fortune. The support QDRO is a distinct legal instrument that shifts the 401k from being a static pile of savings into a functional stream of monthly income. In the American social landscape of 2026, we are seeing a massive surge in the use of these orders as a solution for the liquidity crisis facing many divorcing households. While a standard property QDRO divides the account into two separate pots, a support QDRO is specifically designed to satisfy alimony or child support obligations. This is particularly common in cases where the payer spouse is asset-rich but cash-poor, a scenario frequently seen among retirees or those whose wealth is tied up entirely in employer-sponsored plans. Imagine a case study involving Anthony and Sophia. Anthony is 63 years old and has recently retired from a long career in civil engineering. His primary asset is a $2.5 million 401k. However, because he is no longer earning a salary, he has very little monthly cash flow. Sophia, who spent 20 years managing the household and supporting Anthony's career, is entitled to significant spousal support. In a traditional 2026 divorce, Anthony might be forced to sell the family home or liquidate other assets to pay Sophia every month. But under a support QDRO, the court can order that a portion of Anthony's monthly 401k distribution be paid directly to Sophia by the plan administrator. This is a massive tactical advantage for Anthony because it offloads the tax burden. Under Section 414P of the Internal Revenue Code, when 401k funds are paid out for support, the tax liability typically follows the money. If the plan sends $4,000 a month to Sophia, she is responsible for the income tax on that amount, not Anthony. Furthermore, just like the property split we discussed earlier, these support payments are exempt from the 10% early withdrawal penalty. This allows a younger spouse to receive support from a retirement account without the IRS taking an extra cut, making the 401k a highly efficient engine for alimony. However, this leads us directly into the most controversial debate in modern American family law: the double dip. This is a concept that every student of social studies and finance must master. The double dip occurs when a retirement account is treated as an asset to be divided today, and then treated as a source of income for alimony tomorrow. Let's look at the logic. In Anthony and Sophia's case, if the court first divides the $2.5 million 401k equally, each spouse gets $1.25 million. At this point, the property has been settled. However, if the court then looks at Anthony's remaining $1.25 million and says, "You must use the income generated by this money to pay Sophia alimony," many legal scholars argue that Anthony is being taxed twice on the same asset. He already gave Sophia half the account. Now he is being asked to give her a portion of the half he kept. Historical trends in the United States show a deep divide on this issue. Some states, like New Jersey and Florida, have passed specific statutes or have case law that prohibits or severely limits double dipping. They argue that once an asset is divided as property, its future income stream is off-limits for support calculations. Other states take a more holistic view, arguing that the court must look at the actual cash available to each person to ensure a fair standard of living, regardless of whether that cash comes from a previously divided asset. In 2026, this is the front line of divorce litigation. Attorneys are hiring actuarial experts to determine exactly which portion of a 401k payment is principal, which was already divided, and which portion is new growth or interest, which might still be fair game for alimony. Step by step, if you are negotiating a 401k division, you must clarify in your settlement agreement whether the retirement assets being divided will be excluded from future alimony calculations. If you leave this ambiguous, you are inviting a second legal battle 10 years down the road when retirement begins. This brings us to the psychological and financial warfare of the valuation date. In the volatile markets of 2026, the specific day you choose to value a 401k can change the outcome of a divorce by 6 figures. Most people assume the value is simply what is on the statement, but those statements are usually monthly or quarterly. If the market experiences a flash crash or a sudden tech-driven rally, the statement from 30 days ago is a work of fiction. Imagine if Anthony and Sophia filed for divorce on February 1, 2026. On that day, Anthony's 401k was worth $2.5 million. But let's say the tech sector, which makes up a large portion of his 401k's index funds, suffers a 15% correction in March. By the time they get to mediation in April, the account is only worth $2.125 million. If the court uses the date of filing as the valuation date, Sophia might be awarded a fixed dollar amount based on the $2.5 million figure. She would get $1.25 million, leaving Anthony with only $875,000. He effectively absorbs 100% of the market crash. To weaponize this, attorneys often engage in tactical delays or accelerations. If the market is rising, the spouse who does not own the account wants a valuation date as late as possible, the date of trial or the date of the decree, to capture the growth. The spouse who owns the account wants the date of filing or separation to lock in a lower value. In a 2026 economic environment characterized by high-frequency trading and rapid shifts in sentiment, the choice of a Tuesday versus a Friday for a valuation point can be the difference between a comfortable retirement and a financial disaster. The most sophisticated way to handle this is the use of the pro rata market adjustment. Instead of awarding a specific dollar amount, the QDRO awards a percentage of the account as of a specific date, plus or minus the market gains and losses until the date of distribution. This ensures that both Anthony and Sophia are in the same boat. If the market goes up, they both win. If it crashes, they both share the pain. This removes the incentive for either party to drag their feet in the legal process. We must also consider the concept of the present value discount. This is used when one spouse wants to keep the entire 401k and give the other spouse a different asset, like the family home, to offset the value. This is called a trade-off or a buyout. However, you cannot trade $1 in a 401k for $1 of home equity. Why? Because the home equity is largely tax-free, while the 401k is 100% taxable. In 2026, a professional forensic accountant will apply a tax-affecting discount. If the 401k is worth $1 million, the accountant might argue its real-world value is only $750,000 because of the deferred tax liability. If you are the spouse receiving the house, you want the 401k valued as high as possible so you get more house equity. If you are the spouse keeping the 401k, you want it valued as low as possible. This negotiation over the discount rate is a masterclass in financial sociology. It involves predicting future tax rates, which in 2026 is a guessing game based on the current political climate and national debt levels. As we peel back these layers of support orders, double-dipping, and valuation warfare, we begin to see that the 401k is not just a bank account. It is a living, breathing legal entity that responds to the specific words used in a court order. But there is a hidden danger that can override everything we have discussed so far. There is a specific federal doctrine called ERISA preemption. It is the nuclear option of retirement law. It means that even if a state judge orders something, if it conflicts with federal law, the federal law wins every single time. This leads to situations where a spouse wins a hard-fought battle in a local courtroom, only to have the 401k plan administrator laugh at the order because it violates a technical federal rule. In the next part, we are going to explore the ERISA preemption traps, the malpractice landmines that catch even the best attorneys, and the secret way that employer-matched contributions can be clawed back if the divorce happens too soon. We will also reveal the one document that is even more powerful than a QDRO, which almost no one ever talks about until it is too late to sign it. The concept of ERISA preemption is often described by legal scholars as the nuclear option of American retirement law. ERISA, or the Employee Retirement Income Security Act, is a federal statute that effectively acts as a protective shield around employer-sponsored retirement plans. Because it is a federal law, it carries the weight of the Supremacy Clause of the United States Constitution. In simple terms, this means that if a state law or a state court order contradicts the rules established by ERISA, the federal law wins every single time. This creates a terrifying reality for many Americans in 2026 who believe their divorce decree is the final word. Imagine a character named Brandon. Brandon is going through a contentious divorce in a state that follows equitable distribution. The state judge, wanting to be fair, signs an order that says Brandon's ex-spouse is entitled to 70% of his 401k because Brandon is keeping the high-value family business. Brandon feels secure. He has a court order signed by a rogue judge. However, when that order is sent to the plan administrator, it is flatly rejected. Why? Because the plan documents, governed by federal ERISA standards, might only allow for a maximum 50% transfer in a single transaction, or perhaps the order didn't meet the hyper-technical definition of being qualified. In this scenario, Brandon's ex-spouse has a piece of paper that is legally unenforceable against the 401k plan. Brandon is now stuck in a legal limbo where he owes a debt he cannot pay through the intended asset, leading to potential contempt of court charges or a total restructuring of the settlement. This is the heart of the ERISA preemption trap. State courts handle the divorce, but federal law handles the money. This jurisdictional disconnect is where most 401k divorces fall apart. To bridge this gap, you must understand the administrative review process. In 2026, most large plan administrators have an entire department dedicated solely to QDRO compliance. These departments do not care about your marital history, your financial struggles, or what the judge intended. They only care if the four corners of the document match the plan's requirements. If the document refers to the 401k as a pension plan when it is technically a profit-sharing plan, it will be rejected. If it lists the wrong employer identification number, it will be rejected. Historical trends indicate that nearly 40% of initial QDRO submissions are rejected on the first pass. This leads to what we call the malpractice landmines. These are the small technical errors that even seasoned attorneys make. For example, Many orders fail to address what happens to the dividend payments and interest that accrue between the date of valuation and the date of actual transfer. In a high-growth 2026 market, an account could generate thousands of dollars in dividends in just a few months. If the QDRO is silent on who gets that growth, the plan administrator will often freeze the account, refusing to move a single penny until a new corrected order is signed by the judge. This can add months of delay and thousands of dollars in additional legal fees. Now let's talk about the clawback of employer contributions. This is a specific danger for people who are divorcing early in their careers or shortly after starting a new job. Most 401k plans involve a vesting schedule. Imagine if Brandon's employer matches his contributions dollar for dollar. But those matches don't truly belong to Brandon until he has worked for the company for 5 years. This is known as a cliff vesting schedule. If Brandon gets divorced in year 4, he might see a $200,000 balance on his screen, but $50,000 of that is unvested employer money. If the QDRO is written to give the ex-spouse half of the total balance, and then Brandon leaves the company or is laid off before year 5, that $50,000 is clawed back by the employer. The account balance drops instantly. However, the QDRO might still legally obligate the plan to pay the ex-spouse $100,000 based on the original $200,000 figure. Brandon is then left with only $50,000 instead of the $100,000 he expected. He has essentially subsidized his ex-spouse's retirement with his own separate share because he didn't account for the vesting risk. In the social studies of 2026 labor trends, where job hopping is the norm, vesting schedules are a primary cause of post-divorce litigation. We must also distinguish between the two main types of QDROs, the separate interest approach and the shared interest approach. This choice will define your lifestyle for the next 30 years. The separate interest QDRO is the gold standard for 401k accounts. It essentially carves out a piece of the account and gives it to the ex-spouse to manage as their own. They can choose their own investments, name their own beneficiaries, and decide when to start taking withdrawals. It provides a clean break. The shared interest approach is more common for traditional pensions or annuities. In this scenario, the ex-spouse doesn't get their own account. They simply get a slice of every check the participant receives in the future. This is dangerous because the ex-spouse's income is tied to the participant's life. If the participant dies and there is no survivor benefit, the ex-spouse's income stops immediately. In 2026, we are seeing more people mistakenly use shared interest language for 401k accounts, which creates a messy, lifelong financial entanglement that neither party actually wants. But even with a perfect QDRO, there is one document that is even more powerful. It is the document that almost no one talks about until it is too late, the spousal waiver. Under federal ERISA law, a spouse has an automatic right to be the beneficiary of a 401k. This right is so strong that even a prenuptial agreement signed before the wedding is often insufficient to waive it. Why? Because under ERISA, only a spouse can waive spousal rights. Since you aren't a spouse until after the wedding, a pre-wedding waiver is technically invalid for a 401k. This is a massive shock to many couples in 2026. You could have a prenup that says, "I keep my 401k and you keep yours." But if you don't sign a postnuptial spousal waiver the day after the wedding, federal law still gives your spouse the right to that account. If you divorce and that waiver was never signed, the 401k is wide open for division regardless of what your prenup said. This is the ultimate trump card. The QDRO is a tool to divide the asset, but the spousal waiver is the only tool that can prevent the division in the first place. As we look at these potential outcomes, we see a pattern of complexity that rewards the prepared and punishes the assumptions of the uninformed. We have covered the federal supremacy of ERISA, the technical rejection rates of plan administrators, the vesting traps that can drain an account, and the difference between separate and shared interests. But there is another layer to this story that involves the psychological state of the participant. What happens when the participant decides to fight back? What happens when they intentionally try to lose money or take out secret loans to spite their ex-spouse? In the next part, we are going to look at the dark side of 401k divorce, the breach of fiduciary duty. We will explore how courts handle intentional dissipation of assets, the forensic tools used to track down hidden withdrawals, and the specific way a judge can reallocate other assets to punish a spouse who tries to drain their 401k before the QDRO is signed. We will also reveal the reverse QDRO, a rare legal move used to recover money that has already been wrongfully withdrawn from a retirement plan. The concept of fiduciary duty within the context of a marriage is one of the most misunderstood aspects of American social studies and family law. In 2026, many 401k participants operate under the dangerous assumption that because the account is in their name, they have an absolute right to manage it however they see fit until the very second a judge signs the final decree. This is a catastrophic error that ignores the legal reality of marital partnership. From the moment a divorce action is commenced, and in some states even from the moment a marriage has irretrievably broken down, each spouse owes a fiduciary duty to the other regarding marital assets. This means that you are no longer just an account holder. You are a trustee of a fund that partially belongs to someone else. Imagine a case study involving a character named Thomas. Thomas is a high-level project manager who has spent 20 years building a 401k currently valued at $800,000. His spouse, Elena, has been a stay-at-home parent for much of their marriage, contributing to the household in ways that allowed Thomas to maximize his career earnings. When Elena files for divorce in early 2026, Thomas feels a sense of profound personal grievance. He views the 401k as his exclusive property. In an act of what social scientists call financial scorched earth, Thomas decides that if the court is going to take half of his money, he will ensure there is much less to take. Thomas begins a series of aggressive, high-risk trades within his 401k's brokerage window. He moves his entire balance from stable index funds into highly volatile, leveraged derivatives that he knows have a high probability of failing. He also takes out the maximum allowable $50,000 loan, claiming a fictitious hardship, and spends the cash on a luxury international excursion and expensive gifts for his siblings. By the time the final financial disclosures are due, the account balance has plummeted from $800,000 to $500,000. Thomas believes he has successfully lost $300,000 of Elena's potential share. However, the American legal system in 2026 has developed sophisticated forensic tools to counter this specific type of behavior, known as the intentional dissipation of marital assets. Dissipation is defined as the use of marital property for the sole benefit of one spouse, for a purpose unrelated to the marriage, at a time when the marriage is undergoing an irreconcilable breakdown. In Thomas's case, his sudden shift from conservative investing to reckless gambling, coupled with a suspicious hardship withdrawal, creates a clear pattern of bad faith. The forensic process begins with the step-by-step audit of the 401k transaction history. In 2026, forensic accountants utilize AI-driven, anomaly detection software to scan years of retirement data in seconds. These tools look for the divorce spike, a sudden change in login frequency, a shift in risk profile, or a cluster of withdrawals that deviate from a decade of historical trends. For Thomas, the digital footprint is undeniable. The software flags that his aggressive trades were executed at 2 a.m. from a VPN, immediately following a heated mediation session with Elena. This data provides the intent that judges look for when deciding whether to apply the add-back remedy. The add-back is one of the most powerful tools in the judicial arsenal. If the court finds that Thomas dissipated $300,000, the judge will treat the 401k as if that money still exists. In the eyes of the law, the marital pot is still $800,000. When it comes time to divide the assets, the judge may award Elena her full $400,000 from the remaining $500,000 in the account. This leaves Thomas with only $100,000. He has essentially spent his own share of the retirement fund before the divorce was even over. The court does not care that the money is physically gone. They will balance the scales using whatever assets remain, including the equity in the home or other bank accounts. But what happens if there are no other assets to offset the loss? What if Thomas spent the 401k and has nothing else left to his name? This brings us to the reverse QDRO, a rare and technically complex legal maneuver that is gaining traction in 2026. A standard QDRO moves money from a participant to an alternate payee. A reverse QDRO, however, is used to claw back funds that were wrongfully distributed, or to attach a participant's future interest in a different retirement plan to satisfy a judgment for dissipation. If Thomas has a secondary pension or a different 401k from a previous employer, the court can issue an order to seize those funds to compensate Elena for the 401k money Thomas wasted. There is also the psychological warfare aspect of 401k division. We see a historical trend where participants try to hide money within the 401k by creating artificial losses. They might buy shares in a private equity fund or a small business where they have a secret agreement to be bought out at a higher price after the divorce is final. In 2026, the Department of Labor has increased its oversight of these self-directed 401k options because they are so frequently used to obfuscate wealth during marital dissolution. A forensic deep dive doesn't just stop at the statement balance. It looks at the underlying valuation of every asset within the plan. If you invested $100,000 of 401k money into a friend's startup that suddenly became worthless during your divorce, the court will demand an independent appraisal of that startup. If the valuation is found to be manipulated, the participant faces not only civil penalties but potential criminal charges for perjury and fraud. This leads to the concept of judicial reallocation. A judge has the power of equity, which in American social studies means the power to do what is fair, even if it deviates from a strict 50-50 split. If a participant has been particularly deceptive or has committed a breach of fiduciary duty, the judge can award the innocent spouse a greater share of the remaining marital estate as a punitive measure. This might mean giving Elena 60% of the remaining assets to account for the emotional and financial stress caused by Thomas's deception. The 401k is often the largest liquid or semi-liquid asset in an American household, making it the primary target for both growth and sabotage. The lesson for 2026 is that every action taken within a retirement account during a divorce is scrutinized under a microscope. The ERISA shield that protects these accounts from outside creditors does not protect a spouse from their own fiduciary obligations to their partner. We have explored the dark side of asset dissipation, the forensic tools used to catch it, and the aggressive remedies like the add-back and the reverse QDRO. But there is another layer to the retirement puzzle that is even more pervasive and affects millions of American public sector workers. It is a concept that creates a massive disparity between private sector employees with 401ks and public sector employees with pensions. It is called the Social Security offset, and it is the reason why some people get to keep their entire 401k while others have to hand over half their pension. In the next part, we are going to dive into the windfall elimination provision and the government pension offset. We will see how these federal rules can accidentally strip a divorcing spouse of their retirement security, and why a 401k in 2026 is actually worth more than its face value when compared to a government pension. We will also reveal the coverture fraction variations that can change your payout based on whether you were a teacher, a police officer, or a corporate executive. If you think the math we have done so far is complex, you are not ready for what happens when the Social Security Administration enters the courtroom. The Social Security Administration operates as a sovereign entity within the American legal system, often standing in direct opposition to the property division rules established by state divorce courts. In the 2026 legal landscape, this creates a friction point that can fundamentally alter the perceived fairness of a 401k split. While a judge in a state court has the authority to divide your house, your cars, and your 401k, they are federally prohibited from touching your Social Security benefits. This is due to the Social Security Act's anti-assignment clause, which prevents any state court from transferring or offsetting Social Security rights in a divorce decree. However, this federal wall does not mean Social Security is irrelevant to your 401k division. In fact, it is often the invisible hand that determines how much of your retirement account you actually get to keep. Imagine a case study involving two professionals in 2026, Kevin and Lisa. Kevin has spent 30 years as a public school teacher in a state where he does not participate in the Social Security system, instead contributing to a state teacher's pension plan. Lisa has spent those same 30 years in the private sector, building a $2 million 401k and contributing the maximum amount to Social Security. On the surface, if the court applies a simple 50-50th split of their retirement assets, Lisa would be entitled to half of Kevin's pension, and Kevin would be entitled to half of Lisa's 401k. But here is the massive structural inequality. Lisa will also receive a full Social Security check every month for the rest of her life, while Kevin will receive zero Social Security benefits. Because the court cannot give Kevin half of Lisa's Social Security, Lisa ends up with significantly more total retirement income than Kevin. This is where the Social Security offset calculation enters the masterclass. In many jurisdictions, including historical trends in states like Ohio and Pennsylvania, courts have recognized that dividing a public pension without considering the other spouse's Social Security creates a windfall for the private sector spouse. To correct this, forensic accountants in 2026 use a step-by-step methodology to determine the Social Security offset. First, they calculate the present value of the Social Security benefits Lisa earned during the marriage. Let's say that value is $500,000. Then, they take that $500,000 and essentially hide it within the calculations. The court might say that since Lisa has $500,000 in a federal benefit that Kevin can't touch, Kevin should be allowed to keep an extra $500,000 of his own pension, or a larger share of the 401k to balance the scales. This is not a direct division of Social Security, but rather a reallocation of other marital assets to account for its value. However, Kevin faces another hurdle known as the Windfall Elimination Provision, or WEP. This is a federal law that reduces the Social Security benefits of workers who receive a pension from an employer who did not withhold Social Security taxes. If Kevin worked a part-time job during the summers for 20 years and earned enough credits to qualify for a small Social Security check, the WEP could slash that check by up to 50% because he also has his teacher's pension. In a 2026 divorce negotiation, Kevin's attorney must argue that his Social Security value is actually much lower than it appears on his annual statement because of this inevitable reduction. If the court doesn't account for the WEP, they might overvalue Kevin's secondary retirement stream, leading to a lopsided 401k split that leaves him underfunded in his 70s. Then there is the Government Pension Offset, or GPO. This affects the spousal or survivor benefits Kevin might expect to receive from Lisa's Social Security record. Under normal circumstances, a spouse is entitled to up to 50% of their partner's Social Security benefit. But because Kevin has a government pension, the GPO can reduce his spousal benefit by 2/3 of the amount of his pension. In many cases, this reduces the Social Security benefit to zero. Imagine if Lisa passes away in 2030, Kevin might expect to receive her full Social Security amount as a widower, only to find out that the federal government will take nearly all of it because he was a teacher. This makes his 401k share even more vital. If he gives away half of his 401k in the divorce thinking he has Lisa's Social Security as a backup, he is walking into a poverty trap. The social studies of the American family also bring us to the 10-year rule. For Lisa to be eligible for any benefits based on Kevin's work record, or vice versa, the marriage must have lasted at least 10 consecutive years. In 2026, we see a trend of what sociologists call strategic timing. If a couple is at the 9-year and 8-month mark, one spouse might desperately try to delay the final decree to hit the 10-year milestone. Reaching 10 years unlocks a federal insurance policy that costs the other spouse nothing. Lisa receiving benefits based on Kevin's record does not reduce the amount Kevin receives. It is a rare win-win in the world of divorce, provided the marriage hits that decade mark. If the divorce is finalized at 9 years and 364 days, that benefit is gone forever. But what about the 401k itself during these Social Security calculations? In 2026, we are seeing a rise in the use of the hypothetical Social Security analysis. Since the court cannot divide Social Security, some experts argue that a portion of the 401k should be treated as a Social Security substitute. They calculate what Lisa would have paid into Social Security if she had been a public employee like Kevin, and they exempt that amount from the 401k division. For example, if Lisa contributed $150,000 to Social Security over the marriage, the court might treat the first $150,000 of her 401k as separate property, only dividing the remainder. This attempt to create equity between different types of labor is the cutting edge of American matrimonial law. Step by step, you must also consider the tax treatment of these different streams. Social Security is often only partially taxable, whereas 401k withdrawals are fully taxable as ordinary income. $1 of Social Security is technically worth more than $1 of 401k. In a deep dive valuation, a professional will apply a higher multiplier to the Social Security benefit when calculating the offset. If you are Lisa, you want the court to ignore Social Security entirely. If you are Kevin, you want every penny of Lisa's future Social Security valued, tax-adjusted, and offset against your 401k obligations. This complexity is why the 401k is often the most manipulated asset in a 2026 divorce. Participants will try to front-load their 401k contributions in the months leading up to a divorce to lower their take-home pay, and argue for lower support payments, while simultaneously building a separate property claim for those new funds. But as we have seen, the intersection of federal Social Security rules and state property laws creates a net that is very hard to escape. The math of the Social Security offset, the bite of the WEP and GPO, and the high-stakes timing of the 10-year rule all serve as a reminder that your retirement security is not found in a single account. It is a composite of multiple legal systems that don't always talk to each other. But there is one more factor that can render all of this math irrelevant. It is a variable that is growing at an exponential rate in 2026, affecting the way we value every dollar in a 401k. It is the cost of living long enough to actually spend the money. What happens when the 401k you fought so hard for is immediately consumed by the rising costs of healthcare and long-term care? In the next part, we are going to explore the intersection of 401k division and the American healthcare crisis. We will look at the health savings account, or HSA, which is often called the 401k for healthcare, and why it is the most valuable asset you might be forgetting to divide. We will also reveal the Medicaid spend-down trap, where a 401k award in a divorce can actually disqualify you from essential government benefits just when you need them most. The health savings account, or HSA, is frequently described in 2026 financial circles as the 401k on steroids because of its unique triple tax advantage. While the 401k is a powerhouse for retirement, the HSA is often the sleeper asset that causes the most friction during the final stages of a deep dive asset division. In the social studies of American healthcare, the HSA has evolved from a niche product into a primary vehicle for long-term wealth. Unlike a 401k, where contributions are tax-deductible and growth is tax-deferred but withdrawals are taxed as ordinary income, the HSA offers tax-deductible contributions, tax-free growth, and tax-free withdrawals for qualified medical expenses. Imagine a character named Gregory. In 2026, Gregory has spent 15 years contributing to a high-deductible health plan through his employer. He has treated his HSA like a second 401k, never touching the funds and instead paying for his medical bills out of pocket to let the balance compound. His HSA is now worth $85,000. During his divorce from Monica, they focus heavily on his $600,000 401k. Monica's attorney realizes that $1 in the HSA is actually worth significantly more than $1 in the 401k because that $85,000 can be pulled out entirely tax-free to cover any medical costs in retirement, whereas the 401k will be eroded by federal and state income taxes. The step-by-step process of dividing an HSA is fundamentally different from the 401k. You do not use a qualified domestic relations order for an HSA. Instead, under Section 1041 of the Internal Revenue Code, the transfer of an HSA interest between spouses incident to a divorce is not considered a taxable event. The historical trend in 2026 shows that many people attempt to simply withdraw the cash and hand it over, which is a catastrophic mistake. If Gregory withdraws that $85,000 to pay Monica her share, he is hit with immediate income tax and a 20% penalty because he is under the age of 65 and the withdrawal wasn't for a medical expense. To do it correctly, the divorce decree must explicitly state that a portion of the HSA is being transferred to the other spouse's HSA. If Monica doesn't have an HSA, she must open one. The funds move from his account to hers, maintaining their tax-advantaged status. This leads us to the broader social implication of the silver divorce healthcare crisis. As Americans live longer, the cost of healthcare in retirement has become the single largest variable in financial planning. Social studies data from 2026 indicates that a healthy couple retiring today may need over $400,000 just to cover medical expenses not met by Medicare. When you split a 401k in half, you aren't just splitting the ability to buy food or travel, you are splitting the ability to afford life-saving treatments. Consider the case study of Eleanor, who is 67 years old and finalizing a divorce after 40 years of marriage. Eleanor has several chronic health conditions. In her settlement, she receives 50% of her ex-husband's $1.2 million 401k. On paper, $600,000 looks like a comfortable cushion. However, Eleanor is now entering the Medicaid spend-down trap. In the United States, if Eleanor's health declines to the point where she requires long-term nursing home care, Medicare will not cover the costs. She would need to qualify for Medicaid. But Medicaid is a means-tested program. In most states in 2026, a single individual cannot have more than $2,000 in countable assets to qualify. The $600,000 Eleanor just won in her divorce is considered a countable asset. Step by step, the government requires her to spend nearly every penny of that retirement fund on her care before Medicaid will step in. If she had remained married, the rules for the community spouse would have allowed her husband to keep a significantly higher portion of their shared assets, while she qualified for care. By divorcing, Eleanor has effectively traded her long-term government safety net for a lump sum that might be exhausted in just a few years of high-acuity care. Potential outcomes for Eleanor include total asset depletion, leaving no inheritance for her children, and leaving her with only the bare minimum of state-provided care. In 2026, forensic experts are also looking at the impact of COBRA and health insurance premiums as a form of hidden 401k erosion. If Monica, from our earlier example, loses her health insurance because of the divorce, she may have to pay for COBRA coverage, which can cost $1,000 to $2,000 a month. If the court doesn't provide for this, she might be forced to take early distributions from her newly awarded share of the 401k. As we discussed earlier, if she is under 59.5 and doesn't use the specific QDRO cash-out exception correctly, she will lose a massive chunk of her retirement to taxes and penalties just to keep her health insurance active. Historical trends show that the spouse who is not the primary policyholder often sees their net wealth decline 20% faster in the first 3 years post-divorce due to these healthcare-related costs. There is also the concept of the HSA as a reimbursement tool for the past. This is a deep dive secret that savvy negotiators use in 2026. If Gregory and Monica have boxes of old medical receipts from their marriage that they paid for out of pocket, the owner of the HSA can use those receipts to pull money out of the HSA tax-free at any time, even years later. In a divorce negotiation, these receipts are like hidden cash. If Monica gets the HSA and the receipts, she can immediately reimburse herself for 10 years of past surgeries and dental work, effectively turning the HSA into a tax-free checking account. This is why a professional audit of a 401k divorce must include a line item search for unreimbursed medical expenses. The intersection of 401k assets and government benefits doesn't stop at Medicaid. For those receiving Social Security disability insurance or other specialized federal credits, a sudden influx of 401k money via a QDRO can trigger a review of their eligibility. While the 401k itself might be an exempt asset while it is in the account, the minute you start taking required minimum distributions at age 73, that income can push you over the threshold for other benefits, including the subsidies for the Affordable Care Act. In the social studies of American wealth, the 401k and the HSA are the two pillars of the private safety net. When you dismantle a marriage, you are not just dividing money, you are recalculating the survival probability of two separate individuals. We have seen how the HSA is a superior asset for medical costs, how the Medicaid spend down can vaporize a lifetime of savings, and how the timing of healthcare costs can lead to early 401k depletion. But there is one final piece of the 401k puzzle that is perhaps the most emotionally and legally volatile. It is the role of the 401k in the context of the blended family. In 2026, the majority of divorcing individuals will eventually remarry. This creates a collision between the rights of the first spouse, the rights of the second spouse, and the rights of the children from both marriages. What happens when a QDRO from 20 years ago conflicts with a new spouse's federal right to be the beneficiary? What happens when a 401k participant tries to use their retirement account to pay for a second child's college education, while still owing a share to their first spouse? The legal gridlock of the blended family retirement is the final frontier of our deep dive. In the next and final part of this masterclass, we are going to explore the successor QDRO, the nightmare of the competing beneficiaries, and the ultimate checklist to ensure that your 401k divorce doesn't haunt your estate long after you are gone. We will also reveal the one specific phrase you must include in your will to prevent the federal government from overriding your final wishes for your retirement legacy. The successor QDRO is the final frontier for the modern American family because it addresses the reality of the multi-divorce household. In the social landscape of 2026, many participants find themselves managing retirement assets that have been carved up not just once, but twice or even 3 times. This creates a mathematical and legal gridlock that plan administrators often describe as a logistical nightmare. When multiple court orders attempt to claim a stake in the same account, the federal rules of ERISA provide a strict hierarchy of payment. The general historical trend follows the first in time, first in right rule. This means the first ex-spouse to successfully file a qualified order typically has their claim satisfied before any subsequent orders are processed. Imagine a case study involving a logistics manager named Robert. Robert was married to his first wife, Diane, for 15 years before they divorced in 2010. Diane secured a QDRO for 50% of the marital portion of Robert's 401k. At that time, the account was worth $200,000, and Diane's share was clearly defined. Robert eventually remarried a woman named Chloe. They remained married for another 15 years until their divorce in 2026. During those 15 years, the 401k grew to $1.2 million through Robert's contributions and a decade of market gains. Chloe's attorney now files for a 50% split of the marital portion. However, the plan administrator must now navigate a complex forensic subtraction. They must first honor Diane's original claim, including any market growth that was attributed to her segregated or non-segregated share. Only after Diane's portion is accounted for can the administrator determine what constitutes the marital property for the marriage between Robert and Chloe. If the first QDRO was not drafted with precision, the second divorce can trigger a total collapse of the account's accounting, leading to a freeze that can last for years while forensic accountants untangle 3 decades of data. This leads us to the potential outcomes of the plan maximum limit. ERISA plans generally cannot be ordered to pay out more than 100% of the account balance. While this sounds obvious, we see scenarios in 2026 where competing orders, when combined with market losses or outstanding loans, attempt to claim 110% of the available cash. In these cases, the plan administrator will reject the successor QDRO entirely. Chloe would then be forced to seek an offset from other assets, such as Robert's home equity or personal savings, because the 401k is effectively tapped out by federal law and the prior claim of the first spouse. Beyond the competition between ex-spouses, we must address the collision between a former spouse and a current spouse. This is the phenomenon of the ERISA trump card. Under federal law, a current spouse has an immediate, automatic right to be the beneficiary of the 401k. If Robert had remarried a third time to a woman named Maria, and then passed away before Chloe's QDRO was finalized, Maria would technically be the legal beneficiary under federal statutes. Chloe might have a signed divorce decree from a state judge saying she is entitled to the money, but if the QDRO was not yet accepted by the plan, Maria could walk away with the entire account. This brings us to the high-stakes world of estate legacy. Many Americans believe that their last will and testament is the final authority on who gets their money. In the social studies of 2026 retirement law, this is one of the most dangerous myths in existence. A 401k is a non-probate asset. This means it bypasses the will entirely. The plan administrator is legally required to pay the person listed on the beneficiary designation form, regardless of what the will says. If you leave your 401k to your children in your will, but your ex-spouse is still listed on the employer's beneficiary form, the ex-spouse gets the money. The children would then have to sue the ex-spouse in state court to try to claw that money back. A process that is expensive, uncertain, and often blocked by federal preemption. However, there is one specific phrase you must include in your will to create a legal foothold for your heirs. While it is not a substitute for changing your beneficiary forms, it acts as a secondary safety net. The phrase is as follows: I intend for this will to serve as a specific act of revocation of any and all prior beneficiary designations for my employer-sponsored retirement plans, and I hereby designate my estate as a constructive trustee for any funds distributed from such plans to an unintended beneficiary. By including this language, you are signaling to the state court that if the 401k money is paid out to an ex-spouse due to a clerical error or federal preemption, that ex-spouse is holding the money in a constructive trust for your intended heirs. It gives your children a cause of action to sue for the return of the funds based on your clearly stated testamentary intent. In 2026, we are seeing more judges uphold these constructive trusts as a way to circumvent the rigidity of ERISA without actually violating federal law. As we reach the conclusion of this 10-part masterclass, let us conduct a final forensic check of the 401k divorce architecture. We have explored the shift from pensions to 401ks and how that moved the risk onto the individual. We have broken down the coverture fraction and the mathematical heart of the marital split. We have analyzed the tax traps of the 72T exception and the danger of rolling funds into an IRA too quickly. We have looked at the psychological warfare of valuation dates and the forensic tools used to catch the intentional dissipation of assets. We have even navigated the collision between 401ks and the Social Security Administration and the rising threat of the Medicaid spend down. Step by step, the 401k divorce is a journey through the most complex intersection of American life, the place where personal love meets federal law. The takeaway for 2026 is that the account statement you see on your screen is not a static number. It is a fluctuating legal claim that is subject to the rules of your employer, the statutes of your state, and the supreme authority of the federal government. To protect your share, you must move beyond the simple division of numbers and master the language of the QDRO. The information gap we identified at the beginning of this series is the primary reason why wealth is lost during divorce. By understanding the successor QDRO, the spousal waiver, and the tax affecting of assets, You have equipped yourself with the forensic depth required to navigate this transition. But the 401k is only one part of the American economic story. While we have mastered the division of retirement savings, there is an even larger asset class that is currently undergoing a massive legal shift in 2026. The primary residence, once a simple split of equity, is being transformed by new federal housing policies and a volatile interest rate environment that makes traditional buyouts almost impossible. How do you divide a home when neither spouse can afford a new mortgage at 2026 rates? In our next deep dive series, we will transition from the retirement account to the family home, exploring the world of mortgage assumptions, equity sharing agreements, and the new social studies of the post-divorce housing market. The 401k was the foundation. The home is the next battleground.